This was the big question, Connell, and this is what we learned today. Alvin Bragg said that he is going to move forward with a retrial of Harvey Weinstein. There was some question about whether or not New York would actually do that. Number one, he's already convicted in California, 16-year sentence. Number two, they're going to be limited on the evidence that can come into the courtroom this time around, and that all relates back to the appellate decision. Prior bad acts evidence is what it's called, allowing other people to testify even though they're not part of the charged crime, and the issues that they testified about and what they testified about was never charged separately. So all of that's going to be relating to the new trial. It has a big effect. It's going to rise and fall on the testimony of the two victims. And so it's going to be up to a new jury who's not going to hear about what's called propensity evidence to make that determination about whether or not prosecutors fulfilled their burden beyond a reasonable doubt. I will say, yes, it's going to be tough for Harvey Weinstein to get a jury who doesn't know about him, doesn't have name recognition, hasn't formulated an opinion about him, especially the second time around in New York. Right. So his 16-year sentence. This was all about whether or not he was remanded and remanded to jail. His lawyers argued that he's in poor physical condition, shouldn't be remanded. He's serving that 16-year sentence. That's also going to be appealed, which might be part of the motivation for New York to actually move forward with a new trial. The First Amendment only applies to the government trying to stifle speech. So that would apply to public universities, not private universities. So private universities, what is condoned by the school relating to protest or speech will rise and fall with their own policy. So it's going to be dictated by that. So each and every one of these schools should be handling those policies and executing them in a neutral way, or otherwise potentially opening themselves up to other liabilities. Say another group comes in and wants to do the same exact thing as this particular group, and they have not enforced what's on their books. Well, then that opens up that discussion of, well, there's not a neutral application to each group, and it's depending on the message. I foresee a lot of lawsuits and a couple different theories of liability. So from the protesters, there's going to be an analysis about whether or not what they're doing. You know, in New York here, we're seeing tents, we're seeing occupation of buildings. There's something called the time, place, and manner test. It has to be reasonable. The other piece is, was this an imminent threat? Was there an imminent threat which would take this out of the free speech arena? So that's all the analysis, whether or not those protesters will have veracity to their claims. The other side is discrimination, because Jewish students are now claiming that they've been deprived of actually being able to access the school. They can't go in. Their key cards are shut down. So that would mean that they don't have equal access under the law, which is required under statutes like Title VII of the Civil Rights Act. So it would be two different analysis. One would be more like a contractual law claim. A Title VII discrimination claim has to be based on protected class status. So yes, any student would have a case. It would be a different case depending on that individual. Just the dichotomy of the two stories, Nicole, they could not be more different. And we heard that in the opening statements today. So obviously the prosecution very focused on the acrimonious relationship between O'Keefe and the defendant. In addition to that, focused on some forensic evidence, because this trial is going to be highly, highly technical in the sense we're going to hear a lot of experts testify about both sides of the story. Now, the defense, they are using that third-party culprit defense, but the judge did not allow them to actually set out exactly what that means in opening statements. They said you can, the judge said that you can establish it through the evidence that comes into the courtroom, but you're going to have to do just that and have those building blocks. So they talked about it in a broad way. But this idea of a conspiracy is going to have to be hashed out as the case goes on. So a lot to watch here. And again, a highly technical, expert-heavy case. What is going on? For her defense team, these statements that were made, this is going to be a big problem, because these are going to be seen as admissions. I hit him, and they're going to have to get around that. The other piece of this is convincing a jury of a conspiracy. It's complicated. A lot of times jurors are going to look at what makes the most sense from a common sense perspective. You don't leave common sense at the door. So convincing a jury that this was a widespread conspiracy, that's going to have some issues. And from a legal perspective, technically, you almost put the burden back on yourself as the defendant to lay that all out. So you don't have the burden as a defendant, the prosecution does. So you're sort of taking that on to set up that third party culprit defense in a way that's so highly convoluted as in this case. And the last piece, Nicole, this to me is the biggest problem, and we're not talking about it that much. It's that she was intoxicated, blew 0.13. So she was intoxicated at the time. So saying that she wasn't the one who did it, she didn't hit him, well, there's going to be an argument that perhaps she just doesn't recall exactly what happened that night.
Right.
Well, there's a federal investigation into this case relating to the way that the investigation was conducted. So part of the defense argument here is that all the eyes were on Karen Read right from the beginning, that, you know, because there was this relationship in the police department between Boston PD, the owners of the house, and the investigating officers, that a lot of things were not done that normally would be done. There was no search inside the house, no search warrants executed. So the failures of that investigation are likely to come back to bite the prosecution because, of course, they have the burden. So when you're talking about a conservatorship, the estate, meaning Britney Spears, even if attorney's fees are incurred on behalf of Jamie Spears, the estate pays those legal fees. So in the context of this particular issue, who's going to pay the fees? This was on the way to trial in May. And a trial is something where you're going to have to go through every aspect of this conservatorship. Britney Spears and her team were going to argue that there was financial impropriety on behalf of Jamie Spears, using that as leverage to combat some of the payment for these fees. But going through that process, that's why a settlement is a victory. What her attorney said is absolutely true. Going through that process, making the arguments at trial, it's re-traumatizing. So coming to this resolution, even though we don't necessarily know the terms, and it sounds like Britney might be paying the fees, it gives finality. It ends the whole process so she can move on.
I want to stick with you, Misty.
At this point, this is over, so it would have to be an entirely new proceeding. It's called de novo review. So everything that's already happened, the conservatorship has been extinguished. Now the fee aspect and the monetary aspect has been resolved. So if there were to be any further proceedings relating to a conservatorship, it would have to start from scratch. I doubt we're going to see that. But of course, the videos could be a cause for concern, but it does not necessarily have to go so far as stripping an individual of all of their civil liberties, of having complete control over their person. Obviously, there's steps in between where family and friends could try and help her without going so far as basically taking over her life. There's a couple of really important points here. Number one, Jake, you nailed it, the timing. Remember, this is all part of the prosecution's narrative that this is right around the time the Access Hollywood tape has become public. Trump team is in panic mode to get rid of the Stormy Daniels story. So that's all going to speak to some of the elements that tie this payment directly to the election. Now, the other piece is every single document and communication and transaction relating to this payment is obviously a key and critical part of the case. And to have these shell companies, this is all speaking to that idea of a conspiracy trying to mask these payments as something that they're not. And remember, that is a fundamental part of the prosecution's case as far as this all being unlawful conduct, because the payments themselves aren't unlawful. It's that were they properly reported? Were they related to the campaign? Were they related to the election? So all of this testimony, while foundational, authenticating documents, really, really important to the merits of the prosecution's case.